Section 31. Public when to assist magistrates and police. What the section says in simple English. Every person must help a magistrate or a police officer if they reasonably ask for help in any of the following situations. Helping take or stop someone from escaping arrest. If a magistrate or police officer is trying to arrest someone, or if a person who is being lawfully arrested tries to escape, you are legally required to help them take that person into custody or prevent their escape. Helping stop a breach of the peace. If there's a disturbance or situation that is breaking public peace, like a fight, riot, or similar disorder, and a magistrate or police officer asks you to help prevent or stop it, you must assist. Helping prevent damage to public property. If someone is trying to damage public property, such as government buildings, public infrastructure, etc., and a magistrate or police officer requests your help to stop it, you are required to assist. In short, Section 31 makes it a legal duty of every citizen to assist law enforcement and judicial authorities in situations involving arrests, public peace, or protection of public property when asked reasonably. Section 32 aid to a person other than a police officer executing a warrant. What this section means in simple English. If a warrant, an official order to carry out something like arrest, search, or seizure, is issued to a person who is not a police officer, this law says that other people are allowed to help that person in carrying out the warrant, but only if the person to whom the warrant is addressed is nearby and actively trying to carry it out. Breakdown of the key idea. Warrant directed to a non-police person. Sometimes, a magistrate or court issues a warrant to someone who isn't a police officer, for example, a private person or special officer empowered to execute it. Help by others. In such situations, any other person can assist that individual in executing the warrant. Condition. The help must be while the person executing the warrant is present, near at hand, and actually carrying out the warrant's instructions. In simple terms, if someone who isn't a police officer has been legally given the responsibility of executing a warrant, you may help them in doing that job, provided they are right there and actively doing it. This provision ensures that lawful execution of warrants isn't hindered just because a non-police person is involved and may need help from others. Would you like a comparison with the old CRPC provision it replaces? That can help you see how the law has changed. Here's a clear English explanation of Section 33 of the Bharatiya Nagarik Suraksha Sanhita, 2023 BNSS. Section 33. Public to give information of certain offences. What this section means in simple terms. Section 33 makes it a legal duty for every person to report to the nearest police officer or magistrate if they know about a serious offence that has already been committed or the intention of someone to commit such an offence in the future. This obligation applies specifically to a list of certain serious offences defined in the Bharatiya Nyaya Sanhita 2023, the new Penal Code. These include offences related to things like rioting and unlawful assembly, violence and grievous hurt, attempt to murder, harm to others, some public order and public servant related offences, and various property related violent acts. Key points in plain English. If you are aware that someone has committed or is planning to commit one of the listed serious crimes, you must immediately inform the nearest police officer or magistrate. You must do this without delay, forthwith. If you fail to report this knowledge without a reasonable excuse, the law puts the burden on you to prove that you had a good reason for not reporting it. The term offence here also covers acts committed outside India, if they would be considered offences under Indian law. In short, Section 33 says that regular citizens must report information about serious crimes or plans to commit them to authorities immediately, unless they have a reasonable explanation for not doing so. Section 34, Duty of village officers and residents to report certain matters. What this section means in plain English. Section 34 places a legal duty on village officials and everyone living in a village to immediately report important information to the nearest magistrate or officer in charge of the nearest police station, whichever is closer. Who this applies to? Every officer involved in village administration, like panchayat members, village headmen, or other designated village officers. Every person residing in the village. What must be reported? They must without delay communicate any information they possess about any of the following situations. If someone known for dealing in stolen property lives in or near the village, permanently or temporarily. If someone who is a suspected robber, escaped convict, or proclaimed offender comes to or passes through the village. If a serious, non-bailable offence has happened, or someone intends to commit such an offence in or near the village. If there is a sudden or unnatural death, a death under suspicious circumstances, a corpse or part of one is found that raises suspicion, or a person disappears in suspicious circumstances, suggesting a serious crime. If something happens nearby outside India that, if done in India, would be a serious offence under certain specified sections of the Bharatiya Nyaya Sanhita 2023, for example, cases like murder, grievous hurt, kidnapping, robbery, etc. Any other matter likely to affect public order, prevention of crime, safety of people or property, if the district magistrate has issued a general or special order requiring such information. In simple terms, if you are a village official or resident and you have information about serious crime, criminals, suspicious deaths, or activities that threaten safety and order, You must report it immediately to the nearest magistrate or police officer. This helps law enforcement act quickly and keeps the community safer. Section 35. When police may arrest without a warrant. Purpose of this section. Section 35 tells us in what situations a police officer can legally arrest someone without getting a warrant from a magistrate. It replaces and modernizes the previous CRPC provision on arrest without warrant, combining arrest powers and police notice procedures. Main rules in simple English. 1. Police can arrest without warrant in certain serious cases. A police officer may arrest someone without a court order or warrant if any of the following are true. The person commits a cognizable offense right in front of the officer. A serious crime police can investigate immediately. There is reasonable complaint, credible information, or reasonable suspicion that the person committed a cognizable offense punishable up to 7 years or longer, and the officer believes the arrest is necessary for reasons such as to prevent more crime, to discover evidence, to stop the person influencing witnesses, to ensure they appear in court. The person is a proclaimed offender, officially declared an absconder. The individual is found with something reasonably suspected to be stolen property, and there are grounds to believe they committed a related offense. The person obstructs police while they're doing their duty or attempts escape from lawful custody. The officer has credible information about serious offences committed outside India that would be an offence in India. Other specific conditions like suspects of desertion from armed forces or released convicts breaching conditions. 2. Notices instead of immediate arrest. If the offence is cognizable but arrest is not immediately necessary, the police may issue a written notice directing the person to appear before them like a summons. The person must comply with the notice. As long as they comply, they generally cannot be arrested for that offence. 3. Arrest after failing to comply with a notice. If the person fails to comply with a notice or refuses to identify themselves when asked, the police may arrest them, subject to legal conditions and court orders if applicable. 4. Safeguard for older or infirm persons. No arrest shall be made without prior permission from an officer of a certain rank, deputy superintendent of police or higher, when the offence is punishable with less than 3 years and the person is elderly, above 60, or infirm. This adds a protective safeguard against unnecessary arrests of vulnerable individuals. In plain words, Section 35 allows the police to act swiftly against persons suspected of serious crimes without waiting for a court warrant, but only in specific, justified circumstances. It also includes procedural checks like issuing a notice first when immediate arrest isn't necessary and extra protection for elderly or infirm persons accused of minor crimes. Section 36. Procedure of arrest and duties of the officer making the arrest. What this section means in simple English. When a police officer arrests someone, the law requires the officer to follow certain specific steps and duties so that the arrest is lawful, transparent, and respectful of the rights of the person being arrested. Key duties of the police officer under Section 36. 1. Officer must clearly identify themselves. The arresting police officer must wear or carry visible and clear identification like a name badge or ID so that the person being arrested and others around can easily know who is arresting them. 2. Prepare a written memorandum of arrest. The officer must prepare a formal written record of the arrest called a memorandum of arrest. This document must be attested, signed by at least one witness, usually a family member of the arrested person or a respectable local resident. Be countersigned by the person who is being arrested to show they have been informed about the arrest. This helps ensure that the arrest was done properly and lawfully. 3. Inform certain rights to the arrested person. Unless the arrest memorandum is already attested by a family member, the officer must tell the arrested person that they have the right to have a relative, friend, or someone named by them informed about their arrest. This protects the person's basic right that their family or someone they trust should know they've been taken into custody. Why Section 36 matters? Section 36 protects both accountability and individual rights during arrest. It prevents unlawful or secret arrests by requiring official identification and written documentation. It helps protect the rights of the arrested person by ensuring they know what's happening and that someone can be informed. It creates evidence, the arrest memorandum, about how and when the arrest was carried out, which can be important later in court or review. In short, Section 36 of the BNSS says that when a police officer arrests someone, the officer must clearly identify themselves, make a written record of the arrest with witnesses and signatures, and inform the arrested person of their right to notify a relative or friend. This ensures transparency, legality, and respect for the rights of citizens during arrests. Section 37. Designated police officer and arrest information. What this section means in simple English. Section 37 focuses on how the police system must organize and share information about arrests so that people know what's going on and there is transparency and accountability in policing. Main points explained. 1. The state government must set up police control rooms. The law requires that every district and the state as a whole must have a police control room. These control rooms help monitor and coordinate police activities, especially arrests. 2. A designated police officer must be appointed. In every district and every police station, the state government must appoint a specific police officer, usually not below the rank of assistant sub-inspector. This officer is officially responsible for keeping records of all arrests. 3. Information must be maintained and displayed. The designated officer has to keep accurate details about each arrest, such as names and addresses of the person arrested, the offense they are charged with. These details should be made available to the public, for example, by displaying them at the police station and at the district headquarters, including through digital means. Why this matters? This section aims to make police actions, especially arrests, more transparent and open to public view. By requiring dedicated officers and visible records, it helps the community know who has been arrested and why, reduces the risk of secret or unlawful detentions, supports accountability in the criminal justice process. In simple terms, Section 37 says that the state government must set up police control rooms and appoint specific officers to keep and publicly share information about arrests, such as who was arrested and for what offense. This helps ensure that the public can access reliable information about police activity. Section 38, right of an arrested person to meet an advocate of their choice during interrogation. What this section means in simple English: when any person is arrested and the police are questioning them, the law gives that person the right to meet and consult a lawyer, advocate of their choice during the interrogation. Key points explained. 1. You can talk to a lawyer during police questioning. If someone is arrested by the police and is being interrogated, questioned, they have the right to meet a lawyer they choose. This means the arrested person can seek legal advice while in custody, which helps protect their rights and ensures they understand what is being asked of them. 2. This right is limited to interrogation time. The right to meet the advocate applies during police interrogation. It does not guarantee that the lawyer can be present at all times throughout the entire interrogation. The law ensures access to legal advice during questioning, but the lawyer may not necessarily be with the person for the entire duration of the interrogation. 3. Why this right is important. It helps ensure the arrested person is not trapped without legal knowledge while being questioned. It protects the person from coercion, gives them understanding of their rights, and supports a fair legal process. In short, Section 38 of the BNSS gives every arrested person the right to meet and consult a lawyer of their choice while the police are interrogating them. This is a legal safeguard to make sure people in custody can get legal help and understand their rights during questioning. Section 39. Arrest on refusal to give name and residence. What this section means in simple English. Section 39 allows a police officer to arrest a person without a warrant in a specific situation. When someone has committed or is accused of committing a non-cognizable offense, a minor offense that normally does not allow police to arrest without a warrant in the presence of that officer, and that person refuses to give their correct name and address, or gives a name or address that the officer reasonably believes is false. Why this matters? Police need to know who a person really is to proceed with investigation or take further steps. If someone won't identify themselves or gives false details, the officer may arrest them only to find out their true identity. Key points in plain English. 1. When can the police arrest under this section? Someone has committed or is accused of a non-cognizable offense in front of a police officer. The officer asks for their name and address. The person refuses to give these details or gives false details that the officer reasonably believes are untrue. In this situation, the officer can arrest that person so that their true name and residence can be found out. 2. What happens after this kind of arrest? Once the police ascertain the person's real name and address, the person must be released on a bond or a bail bond, a written promise to appear in court if required. If the person is not a resident of India, the bail bond must be secured by someone who is residing in India. After release, they may still be required to appear before a magistrate if necessary. 3. What if the true identity cannot be found quickly? If the true name and address cannot be verified within 24 hours, or if the person fails to give a proper bond or sureties, then the officer has to send the person immediately to the nearest magistrate with jurisdiction in the case. In short, Section 39 of the BNSS allows police to arrest someone who is accused of a minor offense and refuses to honestly provide their name and address, but only to confirm their true identity. After identity is confirmed, they must normally be released on a bond or produced before a magistrate if true details can't be ascertained quickly. What Section 40 says in simple English. Section 40 of the BNSS deals with arrest by a private person and what must be done after such an arrest. Key points. Who can make the arrest? Any private person, i.e., a regular citizen who is not a police officer, may arrest or cause to be arrested someone who is committing a non-bailable and cognizable offense in their presence, or is a proclaimed offender, a person declared as such by legal authority. What kind of offenses are involved? This applies to serious offenses that are both cognizable, where police can act without a warrant, and non-bailable, meaning bail is not a matter of right. Handing over the arrested person to police. If a private person does arrest someone under this section, they must, without unnecessary delay, hand over the arrested person to a police officer, or if no police officer is available, take them to the nearest police station. Time limit. The law specifically says that the arrested person must be handed over within 6 hours of the arrest. What it means in practice. This section gives a regular citizen the legal authority to arrest someone caught committing a serious crime in their presence, similar to the old CRPC provision. However, after making such an arrest, the private citizen must quickly involve the police and cannot keep the person detained privately. The purpose is to ensure that lawful arrest procedures begin promptly and the person's custody is passed to the proper authorities quickly. Section 41. Arrest by Magistrate, English explanation. What this section means. Section 41 gives a magistrate the power to arrest a person himself or order someone to arrest in certain situations, and also to direct the arrest of a person in other circumstances within his or her jurisdiction. Key points simplified. If an offense happens right in front of a magistrate, if a magistrate, either executive or judicial, sees an offense committed in his presence within the area where he has authority, he can personally arrest the offender or order someone else to do it. After the arrest, the magistrate can commit the offender to custody, i.e., place them in legal detention, subject to any rules about bail. Even if the offense wasn't just committed, a magistrate can also arrest a person or order their arrest in his presence if he is competent to issue a warrant for that person's arrest at that time and in those circumstances. This means a magistrate doesn't need to wait for a police officer. If legally authorized to issue a warrant, he can directly make or order the arrest himself. Purpose of Section 41. This section formalized the authority of magistrates in arrest situations similar to what existed under the old Code of Criminal Procedure (CRPC). It ensures that a magistrate, when present at the spot where an offense occurs, can take immediate arrest action without waiting for police. It also allows magistrates to take direct action when they are legally entitled to issue arrest warrants, keeping the criminal justice process efficient and timely. Section 42. Protection of members of the armed forces from arrest. What this section means. Section 42 gives special protection to members of the armed forces of the Union, like Army, Navy, Air Force, when they are carrying out their official duties. Key points in simple language. Protection from arrest during official duty. If a member of the armed forces is accused of doing something in the course of performing their official duties, they cannot be arrested for that act unless the central government's consent has been obtained beforehand. This applies even if the act is alleged to be illegal or wrongful, as long as it's said to be done while performing official duties. State government extension. The state government can also decide, by issuing a notification, to give similar protection to certain members of forces that maintain public order, for example, state armed police. In such cases, state government's consent would be required instead of the central government's consent. What it means in practice. This section is designed to avoid harassment or interference with armed forces personnel while they perform duties that relate to national security or defense. The purpose is to ensure that such personnel can discharge their official responsibilities without the delay or distraction that might come from an arrest triggered by a complaint, unless the appropriate government authority permits it first. Section 43. Arrest. How it is made. What this section says in simple English. Section 43 explains how an arrest must be physically carried out when someone is being arrested under BNSS. Key points explained. Physical touch or confinement. When a police officer or any person, including a private citizen making a lawful citizen's arrest, arrests someone, they must actually touch or physically restrain the person unless the person voluntarily submits to custody by words or actions. Special provision for women. If a woman is to be arrested, her oral submission to custody is presumed unless circumstances show otherwise. Unless required by special circumstances, or unless the arresting officer is a female officer, a male officer should not physically touch a woman to make the arrest. After arresting her, the officer must give information about the arrest and where she is being held to her relatives, friends, or anyone she identifies. Use of force if needed. If the person resists arrest or tries to escape, the arresting officer or person may use necessary force to complete the arrest. Use of handcuffs. The police officer may use handcuffs based on the nature and seriousness of the offense. For example, if the person is a habitual offender, has escaped custody, or is accused of serious crimes, such as organized crime, terrorism, rape, murder, human trafficking, drug offenses, etc. Restriction on lethal force. Nothing in this section allows the use of deadly force against someone who is not accused of a crime punishable by death or life imprisonment. Arrest timing for women. Generally, a woman should not be arrested between sunset and sunrise unless there are exceptional circumstances. In such cases, a female police officer must obtain prior written permission from a first-class judicial magistrate in whose jurisdiction the arrest is to be made. What it means in practice. Section 43 sets clear procedural safeguards about how arrests must be done to protect dignity, reduce unnecessary force, and preserve legality. The requirement to physically touch or confine the person, unless they submit voluntarily, is meant to confirm that an arrest is actually effected. The special provisions for women aim to respect safety and dignity, especially during sensitive hours. Allowing the use of force or handcuffs is regulated by the seriousness of the offense or resistance by the person being arrested. Section 44. Search of place entered by persons sought to be arrested. What this section means in clear English. Section 44 gives police officers or anyone acting under a valid arrest warrant the authority to search a place if they reasonably believe that the person they want to arrest has entered or is inside that place. Key points explained simply. Demanding entry and search. If a police officer or someone with a warrant thinks that the person to be arrested is hiding inside a house or other place, they can ask the person in charge of the place to let them enter and help search for the person. Forced entry if necessary. If that person refuses to let them in, and entry cannot otherwise be gained without giving the person to be arrested a chance to escape, then the officer or authorized person may enter and search anyway. They can even break open doors or windows after properly announcing their authority and purpose. Special protection for female occupants. If the place is an apartment where a female occupant, not the person to be arrested, is actually living and customarily does not appear in public, the police must inform her that she can leave and give her a reasonable chance to withdraw before breaking in. Rescue from detention inside. Any authorized officer or person making the arrest may also break open doors or windows to rescue themselves or others if they are lawfully inside and are being unlawfully held in the place. What this means in practice. Section 44 balances the need for law enforcement to effect arrests with respect for privacy and dignity. It gives police the power to search premises where an accused person might be hiding. However, before forcing entry, the officer must announce their purpose and demand entry, and must respect cultural sensitivities, e.g., giving a woman an opportunity to withdraw. This section is similar in purpose to the old CRPC provision on entering premises to execute an arrest. Section 45. Pursuit of offenders into other jurisdictions. Section 45 allows a police officer to pursue and arrest a person beyond the limits of his own police station or jurisdiction if that person is legally liable to be arrested. Key points explained simply. Right to pursue anywhere in India. If a person who is to be arrested moves from one police area to another, the police officer may follow and arrest that person in any place within India. The officer does not need a fresh warrant just because the person crossed into another police jurisdiction. Lawful arrest only. This power applies only when the arrest itself is legal under BNSS. For example, arrest with warrant or lawful arrest without warrant. Continuity of police action. The law ensures that criminals cannot escape arrest simply by crossing district or state boundaries. What this means in practice. Police officers are not restricted by local boundaries while chasing or searching for an accused person. This helps in quick and effective law enforcement, especially in cases where offenders attempt to flee to another district or state. It prevents delay and technical hurdles in arrest procedures. Section 46. Arrest of person resisting or attempting to evade arrest. Section 46 explains what a police officer may do if a person resists arrest or tries to escape while being lawfully arrested. Key points explained simply. Use of necessary force. If a person resists arrest or tries to run away, the police officer or person making the arrest may use all necessary means to arrest that person. No right to cause death unnecessarily. The law does not allow causing the death of a person who is not accused of an offense punishable with death or life imprisonment. Balance between authority and safety. The force used must be reasonable and proportionate, only as much as needed to make the arrest. What this means in practice. A person cannot legally resist a lawful arrest. Police are allowed to physically restrain or overpower a suspect if required. However, the law protects individuals from excessive or deadly force except in extremely serious cases. Section 47. Search of a person arrested. Section 47 explains how the police may search a person after arrest and how the property found must be handled. Key points explained simply. Right to search after arrest. When a person is lawfully arrested, the police officer may search that person and take away any articles found on them that are necessary for evidence, safety, or custody. Safe custody of seized articles. All items taken during the search must be safely kept by the police. The arrested person is entitled to a receipt showing the details of the articles taken from them. Special rule for women. If the arrested person is a woman, the search must be conducted only by another woman and with strict regard to decency. Clothing and personal items. Necessary wearing apparel, basic clothing, cannot be taken away if it would affect the dignity of the arrested person. What this means in practice. Police can check for weapons, evidence, or dangerous items immediately after arrest. The law ensures transparency and protection of personal property by requiring a receipt. Special safeguards exist to protect the dignity and privacy of women. Section 48. Seizure of offensive weapons. Section 48 allows a police officer to take away, seize any offensive or dangerous weapons found on a person at the time of arrest. Key points explained simply. Power to seize weapons. If an arrested person is carrying any offensive or dangerous weapon, such as a knife, firearm, or any object that could cause harm, the police officer may seize it immediately. Purpose of seizure. The seizure is done to ensure safety of the police and others, prevent escape or violence, preserve evidence related to the offense, safe custody, and legal procedure. The seized weapon must be kept safely and produced before the court as per legal procedure when required. What this means in practice: an arrested person cannot keep weapons while in custody. Police are legally empowered to neutralize any threat during or after arrest. This section helps maintain law and order and custody security. Section 49. No unnecessary restraint. Section 49 states that a person who has been arrested must not be subjected to more restraint than is necessary to prevent escape. Key points explained simply. No excessive restraint. An arrested person should not be handcuffed, tied, or otherwise restrained unnecessarily. Restraint should be used only when it is genuinely needed, such as when there is a risk of escape or violence. Reasonable and justified action. Police must ensure that any restraint used is reasonable, proportionate, and justified by circumstances. The law discourages humiliation or harsh treatment of arrested persons. Protection of personal dignity. This section protects the dignity and human rights of the arrested individual while still allowing police to maintain custody safely. What this means in practice: arrest does not mean punishment. The person is only being taken into legal custody. Police must balance security with human dignity. Unnecessary handcuffing or physical restraint can be legally challenged. Section 50. Information of grounds of arrest and right to bail. Section 50 makes it mandatory for the police to inform an arrested person about why they are being arrested and about their right to bail, if applicable. Key points explained simply. Reason for arrest must be told. Every person who is arrested must be informed immediately of the full grounds, reasons for the arrest. The police cannot keep this information secret from the arrested person. Right to bail must be explained. If the offense is bailable, the police officer must clearly inform the arrested person that they have a right to be released on bail and they may arrange sureties, people who guarantee their appearance in court. Legal awareness and fairness. This ensures the arrested person knows their legal rights and can take steps to secure bail without delay. What this means in practice: arrested persons must not be kept in the dark about the charges against them. Failure to inform the grounds of arrest or bail rights can make the arrest illegal or challengeable in court. This section strengthens transparency, fairness, and personal liberty in the arrest process. Section 51. Search of arrested person by magistrate. Section 51 gives power to a magistrate to order a search of an arrested person if the magistrate believes that such a search is necessary for justice or investigation. Key points explained simply. Magistrate can order a search. If a person is arrested and brought before a magistrate, the magistrate may direct that the person be searched. Purpose of the search. The search may be ordered to find evidence related to the offense, recover stolen property or documents, ensure safety or prevent concealment of items, proper handling of seized items. Any article found during the search must be safely kept and dealt with according to law. Respect for dignity. The search must be conducted lawfully and respectfully, especially when the arrested person is a woman. What this means in practice. Even after arrest, judicial oversight exists through the magistrate. This section ensures fair investigation while protecting individuals from arbitrary searches. It adds an extra layer of legal supervision to police actions. Section 52. Medical examination of the arrested person. Section 52 allows and regulates the medical examination of a person who has been arrested when such examination is necessary for investigation or evidence. Key points explained simply. Medical examination by a registered doctor. When a person is arrested, a registered medical practitioner may examine the person at the request of a police officer. The examination can include checking injuries, physical condition, or collecting medical evidence. Use of reasonable force if required. If the arrested person resists the medical examination, the doctor may conduct it using reasonable force if lawfully required. Special rule for women. If the arrested person is a woman, the medical examination must be conducted only by a female doctor or under the supervision of a female doctor. Protection of dignity and rights. The examination must be done in a lawful, respectful, and medically appropriate manner. What this means in practice. Medical examination helps in recording injuries to prevent false allegations, collecting forensic evidence, protecting the health of the arrested person. This section ensures fair investigation while safeguarding human dignity, especially for women. Section 53. Examination of accused by medical practitioner at the request of police. Section 53 allows the police to get a medical examination of an accused person when it is necessary for collecting evidence related to the offense. Key points explained simply. Medical examination for evidence. If a person is arrested and the police believe that a medical examination will provide evidence, such as injuries, blood samples, bodily marks, etc., They may request a registered medical practitioner to examine the accused. Types of examinations allowed. The examination may include recording injuries or marks, collection of bodily substances like blood, saliva, hair, semen, swabs, etc. Other scientific or forensic tests required for investigation. These are allowed as per law and medical standards. Use of reasonable force. If the accused resists the examination, reasonable force may be used to conduct it, only to the extent necessary. Special protection for women. If the accused is a woman, the examination must be done by a female doctor or under her supervision. Respect for dignity. The examination must be conducted in a human, lawful, and dignified manner. What this means in practice. This section helps police collect scientific and medical evidence, which is crucial in modern criminal investigations, for example, rape, assault, or violent crimes. It balances effective investigation with personal dignity and legal safeguards. Medical evidence collected under this section is admissible in court if done properly. Section 54. Medical examination of arrested person at the request of the accused. Section 54 gives an important right to the arrested person. It allows the accused to ask for a medical examination to prove their physical condition or injuries at the time of arrest. Key points explained simply. Right of the arrested person. If an arrested person claims that they were ill-treated, injured, or unwell during arrest or custody, they can request a medical examination. Examination by a registered doctor. The examination must be conducted by a registered medical practitioner. The doctor must record all injuries or medical conditions found on the body of the arrested person. Medical report. The doctor must prepare a medical report mentioning the injuries or health condition, the probable time when the injuries were caused. This report becomes important evidence. Protection against abuse. This section acts as a safeguard against police abuse or torture and protects the rights and dignity of the arrested person. What this means in practice. An arrested person can protect themselves legally by requesting a medical check. The medical report can be used in court to support claims of mistreatment. This ensures accountability, transparency, and human rights protection in the arrest process. Section 55. Identification and procedure to be followed by police officer making arrest. Section 55 lays down basic duties and safeguards that a police officer must follow while making an arrest so that the arrest is transparent, lawful, and accountable. Key points explained simply. Police officer must identify himself. The police officer making the arrest must clearly show his identity. He must bear visible identification, such as name, rank, or badge. Arrest memo must be prepared. The police officer must prepare a memorandum of arrest memo. It must be attested by at least one witness, a family member, or a respectable person of the locality, and signed by the arrested person. Information to relatives or friends. The arrested person has the right to have a friend, relative, or any nominated person informed about the fact of arrest and the place where the person is being detained. Time, date, and place of arrest. These details must be clearly mentioned in the arrest memo. What this means in practice. Arrests cannot be done secretly or anonymously. The arrested person and their family must know who arrested them, when and where they are detained. This section strengthens human rights, transparency, and police accountability. Section 56. Person arrested to be taken before magistrate or officer in charge of police station. Section 56 requires that any person who is arrested must be taken without unnecessary delay either. Before a magistrate or to the officer in charge of a police station. Key points explained simply. No unnecessary delay. After arrest, the police cannot keep the person detained arbitrarily. The arrested person must be produced as soon as reasonably possible. Before magistrate or police station. The arrested person must be taken to the nearest police station or directly before a magistrate, depending on the circumstances of the arrest. Legal custody only. This ensures that the arrested person comes under formal legal supervision quickly. What this means in practice. Police cannot hold someone privately after arrest. Judicial or official oversight begins immediately after arrest, protecting personal liberty. This section is a safeguard against illegal detention and abuse of power. Section 57. Person arrested not to be detained for more than 24 hours without magistrate's order. Section 57 puts a strict time limit on police custody. It says that no arrested person can be kept in police custody for more than 24 hours unless a magistrate authorizes further detention. Key points explained simply. Maximum 24 hours rule. A person arrested without a magistrate's order must be produced before a magistrate within 24 hours of arrest. Journey time excluded. The time needed to travel from the place of arrest to the magistrate's court is not counted in these 24 hours. Magistrates control over further detention. If the police want to keep the person in custody beyond 24 hours, they must produce the person before a magistrate and obtain legal permission, remand. What this means in practice? Police cannot detain someone indefinitely on their own authority. Judicial supervision must begin within 24 hours, protecting personal liberty. Detention beyond this period without a magistrate's order is illegal and can lead to legal consequences. Section 58. Police to report apprehensions. Section 58 requires the police to keep proper records and report all arrests, apprehensions, made without a warrant to the appropriate authority. Key points explained simply. Mandatory reporting of arrests. Every police officer must report to the district magistrate or another authority specified by the state government all cases of persons arrested without a warrant. Regular and systematic record. The report must be made in the manner and form prescribed by the state government. This helps maintain a systematic record of arrests. Purpose of the reporting requirement: to ensure transparency and accountability in police actions, to prevent illegal, secret, or arbitrary arrests. What this means in practice? Police arrests are subject to administrative oversight, not just internal control. Higher authorities can monitor patterns of arrest and detect misuse of power. This section strengthens civil liberties and rule of law. Section 59. Discharge of person apprehended. Section 59 explains when and how a person who has been arrested without a warrant must be released, discharged, if there is no sufficient legal reason to keep them in custody. Key points explained simply. Release when detention is not required. A person arrested without a warrant must be released immediately if there is no reasonable ground to keep them in custody, or further detention is not necessary under the law. Who can order the release? The person may be discharged by the police officer who made the arrest, or by the officer in charge of the police station. Bond for appearance, if required. Instead of keeping the person in custody, the police may require them to execute a bond with or without sureties to appear before a magistrate when required, or comply with legal directions. What this means in practice? Arrest does not automatically mean long detention. If the police find that the arrest was unnecessary or further custody is not justified, the person must be released promptly. This section protects people from unjustified or prolonged police detention and supports personal liberty. Section 60. Report of arrest and discharge. Section 60 requires the police to formally report both the arrest of a person and their release, discharge, to the magistrate, ensuring judicial oversight. Key points explained simply. Mandatory reporting to magistrate. When a person is arrested without a warrant and later released, discharged, under Section 59, the police must inform the magistrate about the fact of arrest and the fact and reasons for discharge, transparency and accountability. The report must be made in the manner prescribed by law, creating an official record. Judicial supervision. This allows the magistrate to review police actions and ensure arrests and releases are lawful and justified. What this means in practice. Police actions do not remain internal. They are subject to court oversight. This helps prevent misuse of arrest powers and ensures rule of law. It strengthens personal liberty by keeping the judiciary informed. Section 61. Security for keeping the peace or for good behavior. Section 61 empowers a magistrate to require a person to give security, a bond, to maintain peace or good behavior when there is a reasonable fear that the person may disturb public order.